Namaskar, I am Tejinder and welcome to another wonderful episode of Just Justice. Today we shall be talking about maintenance of wife and children under both the laws, that is Hindu Marriage Act 1955 and Hindu Adoption and Maintenance Act 1956. To answer all your questions, we have with us in our studio Dr. Gagan Preet. Dr. Gagan, welcome to the studio.
Thank you so much, sir.
So, ma'am, first of all, I would like to ask you, who all can claim maintenance under Hindu law?
So, as far as the concept of maintenance is concerned, we have specific legislation under the Hindu law, that is Hindu Marriage Act also has provision for maintenance, and then we have Hindu Adoption and Maintenance Act 1956, under which maintenance can be claimed by different persons. Maintenance can be claimed by wife, by children, by parents, by daughter-in-law, by dependents. There are certain specific relations which have been categorized as dependents under that law. So, all these relations, they can claim maintenance under the Hindu Adoption and Maintenance Act. Although, as far as maintenance of husband is concerned, the husband can also claim maintenance under Hindu Marriage Act. There is no specific provision for the maintenance of husband under the Hindu Adoption and Maintenance Act, but under section 24 and 25 of the Hindu Marriage Act, maintenance can be claimed by the wife as well as by the husband. As far as maintenance is concerned, it is it's like creating a basic provision for the person for the purposes of the clothing, food, medical expenditure and any other such specific thing which is required for the sustenance of the person. So, maintenance provision, it is there under both the legislations, but specific legislation to deal with maintenance, that is Hindu Adoption and Maintenance Act, where maintenance can be provided or can be claimed by different persons, as I told, by wife, by children, by parents, by widowed daughter-in-law, not a married daughter-in-law, but a widowed daughter-in-law, she can claim maintenance, as well as there are certain persons who are dependents. As the very name suggests, dependents, that the relations, they have been categorized under that particular legislations, but for a layman, dependents can be those persons who do not have their own resources, but they are somehow related to the person in question, that is the person from whom the maintenance has been claimed. So, such persons can also claim maintenance under the Hindu Adoption and Maintenance Act.
Ma'am, we have another important question. What are the provisions under Hindu law for the maintenance of wife?
As I just told you that there are specific provisions for the maintenance under Hindu Marriage Act as well as Hindu Adoption and Maintenance Act. For the maintenance of wife, as I told you that there are two provisions under the Hindu Marriage Act, that is section 24 and section 25. Section 24 of the Hindu Marriage Act, it talks about, as in the previous episodes also I discussed this particular aspect, that as far as maintenance under section 24 of the Hindu Marriage Act is concerned, it is known as maintenance pendent light, that is during the pendency of the suit, that is till the time the case is going on or the suit is pending. For that duration, the application can be made by the wife or by the husband also. As we are talking about the maintenance of wife only, so I am portraying, or I am just explaining for the purposes of maintenance of wife, but the provision is for the husband as well as for the wife. But precondition is that the wife should not have an independent source of income. That means she should not be having a specific or an independent source of income. She should not be having a specific resource from which she can sustain herself. although it does not mean that she should not be having any sort of job, because for her mere sustenance she may be doing some odd jobs or maybe some stitching work, something. I am just giving an example, that it does not disqualify her from claiming maintenance. The thing which disqualifies her from maintenance is that she should not have an independent source of income, that she is not as at par with the husband, then she can claim a maintenance. If she is not, she is dependent on the husband, only then the claim of maintenance lies. It may be so that she is well qualified, she has all the resources, her parents are very rich, her brother and sisters are very rich. That does not mean that she loses her claim for maintenance. Her claim for maintenance will always be there, provided she is not in a position to maintain herself, that she does not have an independent source of income on which she can rely and she can enjoy the same status of living which she was enjoying after marriage. That is a very, very important aspect. So, as far as section 24 and 25 of the Hindu Marriage Act is concerned, section 24 is maintenance pendent light, that is during the pendency of the suit an application can be made by the wife for the claim of maintenance from her husband if she is dependent on her husband. And section 25, it is categorized as permanent maintenance. It is a claim for permanent maintenance, and in normal course we say that permanent maintenance can be awarded by the court once the suit for divorce or the decree for the divorce has been granted by the court, that is, that matrimonial issue has now been resolved or it has come to an end, and after that now the husband or the wife, whosoever is the claimant, seeks maintenance. But the nature of maintenance is different under section 25. Under section 25, the maintenance is permanent maintenance. Here I say permanent maintenance because it will be there, or the person will be bound to pay that maintenance during the lifetime. That is, till the time, let us say if the wife does not remarry, or till the time the husband or the wife they are alive, that claim for maintenance will always be there. She will not lose her claim for maintenance over a passage of time. It will be there till the time. The two possibilities are there, that in case she remarries, then she loses her claim for maintenance, or in case she dies, then her claim for maintenance will come to an end. But as far as section 25 of the Hindu Marriage Act is concerned, it is permanent in nature. And under the Hindu Adoption and Maintenance Act also, there is a specific provision under section 18 of this act, where maintenance by the Hindu wife can be claimed. And as far as section 18 is concerned, it clearly provides that it is the responsibility of the husband to maintain the wife for her lifetime. It is the responsibility of a Hindu husband to maintain a Hindu wife during her lifetime. And in addition to that, there is another clause which say that a Hindu wife can live separately and still she can have a claim for maintenance if the reason for living separately falls under the following categories. Like under this particular clause, it is provided that the Hindu wife, if she is living separately from her husband because of the reason of desertion by the husband. Now, desertion is that where the husband has left her alone, deserted her. She is living separately from the husband because the husband is not taking care of her, or he has actually withdrawn from her company. So, if that is the reason, the desertion is the reason for her living separately, but she will have a claim for maintenance from the husband. She will not lose the claim for maintenance from her husband. As far as desertion is concerned, there is no statutory period which has been assigned. It is as far as the desertion as a ground of divorce under the Hindu Marriage Act is concerned, there is a statutory period of 2 years which is provided. But as far as under section 18 of the Hindu Adoption and Maintenance Act, the wife can claim maintenance while living separately from the husband, but she does not lose her claim just because of the fact that she is living separately from the husband if the her case falls in any of these categories. Like as I told you, first is the desertion, but there is no statutory period here which is attached with the clause of desertion. Second is that if the husband has treated his wife with cruelty, if there is a the husband has been subjecting his wife to cruelties, physically abusing her, if that is so, there is a because wherever there is physical cruelty, there is always a threat to the life of the person also, and due to that apprehension, if the wife is living separately from the husband, in that case also she will have a claim for maintenance. Earlier there was a provision with regard to the leprosy also, but there have been recent amendments with regard to that. So now that is no more specific ground, because leprosy has been now done away with the recent amendments. And another thing is that if the wife leaves the husband, starts living separately, without losing that claim for maintenance, and the ground and the reasons for that is that if he has any other wife living. Now this is a very peculiar situation where I say that where the husband has any other wife living. In that case, after 1955, that is after the passing of the Hindu Marriage Act, the husband, a Hindu male cannot have more than one wife at a time, because if he undergoes or if he marries for the second time, that marriage is a void marriage. But because the prior to 1955, that is prior to the enactment of Hindu Marriage Act, if the person was already married, and if today let us say that person has that wife, that is his two wives are alive today, there is a rare possibility, but if such a couple is still alive and he has any other wife living, so just on that ground also the other wife can live separately from the husband without losing her claim for maintenance under the Hindu Adoption and Maintenance Act. Another ground which is provided is that if the husband, he keeps a concubine or he habitually resides with her, that is the wife has left the husband because of the reason that the husband has kept a concubine whom he has brought to that respective home, or he habitually resides with her, he goes and frequently lives with her. So if that is also the reason, then also the wife can live separately from the husband and still claim maintenance from the husband. And another aspect is that where the husband, he has ceased to be a Hindu, because conversion to any other non-Hindu religion, that is also a ground on the basis of which the Hindu wife can live separately from the husband without losing her claim for maintenance under the Act. And in addition to that, there is a provision that any other cause which justifies her living separately from the husband, we call it as a miscellaneous clause, because as I told you, there are certain specific provisions or specific clauses under which she can live separately from the husband without losing her claim for maintenance. But the last clause is any other cause which justifies her living separately, which does not fall in any of the specific grounds, but any other cause which makes her living with the husband difficult, and because of that reason, if she has moved out, she can live separately without losing her claim from maintenance from the Hindu husband. So these are the provisions under which, or the situations under which the maintenance can be claimed by the Hindu wife under Hindu Marriage Act and under Hindu Adoption and Maintenance Act.
Yes, ma'am, you have explained all the provisions in a very comprehensive manner. And now, ma'am, we talk about the children. Whether there is any specific provision of maintenance for children under these laws?
Yes, as far as Hindu Adoption and Maintenance Act is concerned, we do have a specific provision under section 20 of the Act. There is a specific provision that where the maintenance for children can be claimed, and the maintenance of children, whether the child is a legitimate child or an illegitimate child, they do have a right to claim maintenance from the parents, and that claim is till the time of minority. That means that claim is there till the child does not attain the age of majority. That is till the attainment of the age of 18 years or the age of majority. Any child who is legitimate or illegitimate, they can claim maintenance from the parents. So that is provided under section 20 of the Hindu Adoption and Maintenance Act. As far as Hindu Marriage Act is concerned, there is a provision for the maintenance of wife, and in normal course the maintenance of the child is also specified, or it is also provided for under the same clause only. So there is no separate specific provision under Hindu Marriage Act which talks about the maintenance of children. But as far as maintenance of children is concerned, the maintenance can be claimed along with the maintenance of the respective parent, like for example the maintenance of wife is concerned. So the maintenance for children also who have not attained the age of majority, that can also be claimed, because the wife who does not have means for her own sustenance, and if the custody of the children is with her, she needs money for their upbringing also. And it is the even under the uncodified law also, it is considered that it is the responsibility of the father in the very first place to provide for the maintenance of the children. So in the codified law also, this particular aspect has been retained. Rather, it has been widened in the sense that now it is the responsibility of the father as well as the mother to maintain the children. But as far as Hindu Marriage Act is concerned, it does not have a specific provision for the maintenance of the children, but along with the maintenance of the wife or maintenance of the husband, if that is the case, the maintenance of children can also be claimed.
And now, ma'am, another important question: how the amount of maintenance is determined?
See, there is no specific formula which has been provided in any of the legislation, but while assessing or while coming to a decision that what will be the amount of maintenance, number of factors they are considered, like for example the person against whom the claim has been made, what is his source of income, whether the person is in a regular employment, whether the person has any other rental income, whether the person has any other source from which the total income will be seen. Then another thing which will be seen is that how many dependents that person has. Like for example, if a claim of maintenance is made by the wife against the husband, and if the husband has old parents, and let's say let's say those parents, they are aged, they are they are totally dependent upon the son. So in that case, the provision will be made, or it will be considered, it will be an important factor. And let's say if the parents, they are suffering from any chronic disease, or let's say if the custody of the child is with the husband. So all these factors, they will be considered, because we have to see that what is the total source of income in hand, and how many persons are dependent upon that person. That is one factor. Another thing is that while providing for maintenance, like let's say because we are talking about the maintenance of wife, it will be seen that what is the standard of living she has been enjoying after marriage, or what is the status she enjoys in the society in general, keeping in view the income of the husband, then the amount of maintenance will be assessed. No doubt there is no specific formula which says that okay, this much is there, so half of the amount will go as maintenance. There is no such specific formula, but in normal course all these things they are considered, that who is having the custody of the child, what is the amount of maintenance which is spent on the upbringing of the children, on the what is the amount which is required for the maintenance of the dependents, all these factors they are considered, then only a final figure is achieved that okay, this is the appropriate amount which should be given by way of maintenance to the wife or to the husband, whosoever is the claimant.
Okay, ma'am. Can there be any variation or modifications in the amount of maintenance?
Yes, as far as maintenance is concerned, the court will award maintenance once the suit is decided. Like let's say for example, in cases of divorce, once the divorce has been pronounced, along with that if a claim for maintenance has been made, the amount of maintenance would be awarded by the court. But this amount of maintenance is not fixed, in the sense it is not so that now that amount has been provided or has been awarded by the court and it cannot be changed in future. If there are any changes or any modifications or any you can say any change in the situation, or change in, let's say earlier the husband was in a regular job, due to some reasons he has been laid off, his job has gone, or let's say earlier he was not married, after divorce he was single and now he is married, he has own children out of the second marriage also, he has to maintain them as well. So that can be one reason on the basis of which the husband can go to the court and ask that this amount of maintenance should be reduced. On the other hand, let's say the maintenance was initially which was fixed for the wife, that was a meager amount, in the sense that at that time while awarding maintenance to her, the maintenance of children were also provided, but the children were very young at that day. But now they are school going, there are expenditure which is needed for their education and other things, maybe one of the child is suffering from some kind of serious disease. So any kind of medical expenditure which is now to be incurred, which was not there at the time when it was fixed. So because of any of such reasons, I am just giving you few examples, there may be different situations, but any such change in the situation from either party, it is not only the claimant, but even if there is a change in the situation of the person against whom the claim of maintenance has been made, that party can approach to the court for the purposes of modifications or variation in the amount of maintenance.
Ma'am, now what are the effects of transfer of property on the right to maintenance?
See, as far as right to maintenance is concerned, if that right has been attached to a particular property and if that property has been transferred, that right also get transferred. It is only in those particular situations where the transferee has the notice, he knows that on this particular property there is some liability attached with the property, or if the nature of the transfer of property is gratuitous in nature. In these two situations, the claim for maintenance will always remain. But if the transfer of property is is for consideration, that is, it is not gratuitous in nature, in that situation, or if the transferee was never ever aware of this particular fact that this claim for maintenance has been attached to a particular property, in that situation then the claimant cannot claim or any right over that property, or that transfer of property cannot be objected to. But as far as that claim is concerned, if the transferee had the notice of this particular fact that there is a liability attached to the property, or if it was gratuitous in nature, then that claim will always be there. It will not have any effect irrespective of the fact that the property has now changed hands.
Right, ma'am. Ma'am, my last question of this episode is, are there any other provisions for maintenance of Hindu wife under any other secular legislation?
Yes, as far as in today's episode we have discussed the maintenance of wife under the Hindu law. There are specific provisions under under other secular legislation, like under section 125 CRPC. That is, this is a secular legislation and a secular provision where wife, it's a provision for maintenance of wife. It covers for maintenance of wife, children and parents, but as we are talking about the maintenance of wife, so there is a provision under section 125 CRPC, and in addition to that we do have a specific legislation, the Protection of Women from the Domestic Violence Act also. There is a provision for the maintenance of any such wife, although this act does not specifically deal with the maintenance of wife, but because this is a special legislation for the protection of women, so yes, a Hindu wife can even claim maintenance under that particular legislation also. These two provisions, that is under section 125 CRPC and under the Protection of Women from the Domestic Violence Act also, the claim for maintenance remains. It does not mean that now if that claim has been made under the personal law, so the claim cannot be made under the secular legislation. That claim definitely remains, or we do have these specific provisions under which the claim for maintenance, even for a Hindu wife, because these are not religion specific legislation, these are secular in nature, and any wife can claim maintenance under these provisions.
Right, ma'am. So with this, ma'am, we come to the end of today's episode, and I promise you that we'll come up with some more interesting topics in the upcoming episodes. Ma'am, thank you very much for your time.
Thank you so much, sir.
So with this, I say goodbye, and you take care of yourself. Thank you very much.